public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great founder and defender of the Constitution. Our resolution tonight is do President Biden's proposed Supreme Court reforms deserve support? On one side, Senator Sheldon Whitehouse recently argued that, quote, the scandal-plagued Supreme Court is in desperate need of reform to restore its legitimacy in the eyes of the Republic. On the other, former Attorney General Bill Barr wrote how such reforms, quote, would destroy the independence of the judiciary and threaten the civil liberties of all Americans. Tonight, we are proud to host two of Georgetown's own alums. One is a professor, one is a student, Professor Caroline Frederickson, and who will be here remotely, and Mr. Mark Paletta, to debate this critical question. Both of them have truly been on the front lines and in the arena of this debate. Moreover, we are hugely fortunate to welcome Judge Robert Luck from the beautiful Sunshine State to moderate for us and our sub-60-degree weather. We are deeply grateful to the Federal Society and to Georgetown Law for making this debate series a reality. I now recognize Garrett Mayo to introduce our three stellar panelists. Please give our speakers a warm welcome.
Thank you. It is my honor to introduce tonight's speakers. Presiding over this debate is the Honorable Robert J. Luck. Judge Luck serves as a judge on the U.S. Court of Appeals for the 11th Circuit. He was previously appointed to the Florida Supreme Court by Governor Ron DeSantis, and before that served on the 3rd District Court of Appeals in Miami, where he was appointed by Governor Rick Scott. Earlier, Judge Luck served on the 11th Judicial Circuit Court of Florida, and prior to his service on the bench, Judge Luck was an assistant United States attorney for the Southern District was a legislative correspondent for 2 United States senators, a law clerk, and staff attorney to Judge Edward E. Carnes on the 11th Circuit. Judge Luck received his BA from the University of Florida, though I will have to say, roll tide, with the highest honors, and his JD from the University of Florida Levin College of Law, magna cum laude, where he also served as editor-in-chief of the Florida Law Review. Mark R. Paletta is partner at the Schaefer Jaffe LLP. Mr. Paletta previously served for a decade as Chief Counsel for Oversight and Investigations for the House Committee on Energy and Commerce. Mr. Paletta most recently served as General Counsel for the Office of Management and Budget in the Executive Office of the President during the Trump administration. Also, as part of that administration, he helped prepare many nominees for confirmation hearings, including cabinet nominees, several Court of Appeals nominees, and 2 Supreme Court nominees, which, as we all know, during the Trump administration, no pressure there, right? Just easy nomination process. Mr. Paletta also served in the White House as Assistant Counsel to President George H.W. Bush, where he played a key role in the successful confirmation effort of Supreme Court Justice Clarence Thomas, another walk in the park. Mr. Paletta received his BA from Duquesne University and his JD from Georgetown University Law Center, so Hoya Saxa to that. And though she will be here shortly, Professor Caroline Frederickson is a senior fellow at the Brennan Center for Justice and formerly a visiting professor at Georgetown Law. She previously served as president of the American Constitution Society from 2009 to 2019. Before joining ACS, Ms. Frederickson served as the director of the ACLU's Washington Legislative Office and as general counsel and legal director of NARAL Pro-Choice America. In addition, she served as the chief of staff to Senator Maria Cantwell of Washington and deputy chief of staff to then Senate Democratic leader Tom Dashley of South Dakota. During the Clinton administration, she served as special assistant to the president for legislative affairs, and she clerked for the Honorable James L. Oaks of the United States Court of Appeals for the 2nd Circuit, and received her JD from Columbia Law School with honors and her BA from Yale University summa cum laude with Phi Beta Kappa honors as well. So without further ado, let's have a fantastic debate.
Evening, everyone. Good evening. Just listen up and food. If I could, before I begin, let me offer three thank yous. First, thank you to Brady and his team at Georgetown Law Federal Society Student Chapter for their hard work putting together this debate and really all debates that have made up the Daniel Webster debate series. I recommend that you watch the past and future debates if you haven't for the past ones. They are really in the best tradition of civil discourse on the critical legal issues that are facing our nation in the months and the years ahead. Second, thank you to Professor Frederickson, who's going to be appearing over Zoom, and to Mr. Paletta for joining us today. They are busy scholars and lawyers and two of the brightest legal minds in our country. We are blessed that they have joined us today and have taken time out of their schedules to be here to share their wisdom on what I think is this critical and important topic. And then finally, thank all of you for being here. All of you have somewhere else that you could be and probably should be. You have work and studying, family and friends that you should be doing. We're all grateful that you instead chose to be here today. I'm very grateful that you're here. So thank you. As Koheleth, King David's son, said in chapter 1 of Ecclesiastes, quote, "What has been is what will be, and what has been done is what will be done, and there is nothing new under the sun." Borrowing from Koheleth and applying his words to our current public policy debates, George Will wrote, quote, "Washington often illustrates the cyclical theory of history, the theory that life is not one damn thing after another, but the same damn thing over and over and over." Will's words are as true for Supreme Court reform as they are for any other issue that's debated in the marble halls of the buildings here in Washington. Supreme Court reform proposals are not new, and they are part of our cycle of history. For example, just 12 years after the Judiciary Act of 1789, so 12 years after the Constitution, essentially, just 12 years after the Judiciary Act provided for a 6-justice Supreme Court, Congress ended the Justice Circuit writing duties and reduced the number of justices from 6 to 5 after a vacancy appeared on the court. The year after that, in 1802, Congress reinstated the Justices Circuit writing duties and reversed the planned reduction of the number of seats on the court. These are among the first two of many, many proposals over the last 200 plus years to reform the number and duties of the justices and the jurisdiction of the Supreme Court. Some were successful, some were not successful. But in looking over these reform proposals from the last 200 years, they seem to shake out in two categories. In one category seem to be those proposals that address administrative or caseload issues that dog the court. So these proposals tended to have broad-based support in Congress and among the public. In the other category are Supreme Court reform proposals that primarily respond to the court's substantive decisions. These proposals tended to be more controversial and opposed by large segments of the country and Congress. Let me give you an example of each of those two categories. So the Judiciary Act of 1802, which I mentioned before, divided our nation into 6 circuits, with 1 justice of the 6-member Supreme Court assigned to each of the 6 circuits. But with the newly admitted states of Kentucky, Tennessee, and Ohio, and later Louisiana, Illinois, Alabama, and Missouri, Congress added a 7th circuit in 1807, and then an 8th and 9th circuits in 1873. Each time, Congress expanded the size of the court accordingly so that 1 justice was assigned to each of the new circuits. As the final report of President Biden's Commission on the Supreme Court explained, quote, "These expansions served an institutional purpose, providing sufficient judicial machinery for a growing nation." Let me give you another example of Supreme Court reform proposal that primarily addressed caseload issues. So for over 100 years, believe it or not, I know this is hard to understand in the modern context, but for over 100 years, from the Judiciary Act of 1789 until 1891, the Supreme Court had no power to pick and choose its cases. With no other exclusive appellate court and an automatic right to appeal to the Supreme Court in most cases, the court's docket exploded. Just by way of example, in 1860, the Supreme Court had 310 cases on its docket. By the 1890 term, so 30 years later, the court had 1,800 cases on its appellate docket and was obligated to decide every single one of them. The court at that point, by 1890, was more than 3 years behind on its work. Responding to the problem, in 1891, Congress passed the Edwards Act, something that I care a lot about, because Under the Everett Act, for the first time since 1802, the justices were no longer obligated to write circuit. The Act created the Intermediate Appellate Courts, where I work, which shifted the appellate caseload from the Supreme Court to the new courts of appeals. And the Act drastically decreased the Supreme Court's caseload by limiting the right to automatically appeal and by making decisions of the courts of appeals final in several categories of cases. This is the first time that certiorari is introduced to the Supreme Court. Then Professor Frankfurter, decades later, wrote a set of the institutional impact of the Everett Act, quote, "The remedy was decisive. The Supreme Court had once felt its benefits. A flood of litigation had indeed been shut off." The other category is Supreme Court reform proposals that primarily respond to the court's decisions. Perhaps the most famous example, there are some others, but perhaps the most famous example is President Franklin Roosevelt's plan from 1937. As the final report of President Biden's Commission on the Supreme Court explained, quote, "In public, President Roosevelt initially asserted that the court reform was designed to promote judicial efficiency. But Roosevelt soon acknowledged that the real purpose was to alter the future course of the court's decisions. In his fireside chat on March 9th, 1937, the president urged that new blood was needed because the Supreme Court was acting not as a judicial body, but as a policymaking body in invalidating New Deal programs. 4 months after that fireside chat, the Senate Judiciary Committee, controlled by President Roosevelt's own party, voted against recommending the plan to the full Senate. Decades removed from the debate, from the 1937 debate, a wise and experienced senator described on the floor of the Senate what the Judiciary Committee did in 1937. And I want to read to you, it's a long quote, I'm going to read to you what that wise and experienced senator said. Quote, "In an act of great courage, Roosevelt's own party stood up against his institutional power grab. They did not agree with the judicial activism of the Supreme Court, but they believed that Roosevelt was wrong to seek to defy established traditions as a way of stopping activism. In May 1937, the Senate Judiciary Committee, a committee controlled by the Democrats and supporting the political ends, issued a stinging rebuke. They put out a report condemning Roosevelt's plan, arguing it was an effort to punish the justices. That executive branch attempts to dominate the judiciary led inevitably to an autocratic dominance, the very thing which the American commonwealth revolted, and the very thing to prevent which the Constitution in every particular was framed. Our predecessors in the Senate, I'm still quoting, showed courage that day and stood up to their president. And they did so not to thwart the agenda of the president, which in fact many agreed with. They did it to preserve our system's checks and balances. They did it to ensure the integrity of the system." That wise and experienced senator was President Joe Biden. On March 30th of this year, President Biden wrote an editorial in the Washington Post outlining his three-part Supreme Court reform plan. The president didn't go into the specifics in the plan, but here are the broad strokes he laid out, and I'm going to quote directly from the order. Quote, "First, I am calling for a constitutional amendment called the No One is Above the Law Amendment. It would make clear that there is no immunity for crimes a former president committed while in office. Second, we have had term limits for presidents for nearly 75 years. We should have the same for Supreme Court justices. I support a system in which the president would appoint a justice every 2 years to spend 18 years in active service on the Supreme Court. Third, I'm calling for a binding code of conduct for the Supreme Court. Justices should be required to disclose gifts, refrain from public political activity, and recuse themselves from cases in which they and their spouses or their spouses have financial or other conflicts of interest." The announcement by President Biden of his Supreme Court reform plan raises a number of important questions. Is President Biden's plan like the proposals from the last 200 years that are meant to address institutional concerns about the court? Or like President Roosevelt's plan from 1937, does today's plan primarily respond to the court's substantive decisions? Must the Constitution be amended to implement President Biden's plan for term limits and a binding code of conduct? In other words, do President Biden's Supreme Court reforms deserve support? To answer this question, we will hear first from Mr. Paletta and then second from Professor Frederickson. After their opening statements, Mr. Paletta will get a chance for a brief rebuttal, and then he and I will go through some questions, and I hope there's some time at the end for some questions from the audience, and I'll take those. We'll wrap it up with a brief closing statement. And with that, Mr. Paletta.
Thank you all for coming here tonight. Judge, thanks for the very interesting remarks. I'm going to build on some of them. Brady, thanks for the invite here tonight. It's an important topic, so glad to make time for it. So the question, do President Biden's proposed SCOTUS reforms deserve support? No. President Biden's proposal is a dangerous plan. In fact, far more dangerous than FDR's court packing plan in 1937, where FDR sought to add 6 justices and was universally denounced, as the judge referenced. President Biden's plan, like FDR's, is driven by his and the left's outrage at the court's recent rulings, such as Dobbs, Loper Bright, Harvard, and Trump v. U.S. This plan will destroy the court's independence so that it rules in a manner the Democrats deem acceptable. Biden's proposal expands the court to 18 justices over time, with the president appointing a justice in the first and third years of his or her term, and then only provides the 9 most recently appointed justices with appellate and cert jurisdiction, which is 99.9% of the cases the court considers. In effect, the proposal adds justices and actually replaces justices in order of seniority. If this bill were to pass this year, Justice Thomas would be retired from active service in May of 2025, then Justice Alito in 27, and Roberts in 29. This is astonishing. Under our Constitution, justices are appointed for life to an office, and nothing short of a constitutional amendment can change their term of service. Life tenure cannot be circumvented by recategorizing justices' service as excluding all the duties of that office. In addition to being unconstitutional, it's a terrible idea. It will kill judicial independence. There's no limiting principle. In fact, in response, a future Congress could pass a law terminating the active service, as they call it, of every Republican or Democrat appointee to get their way. In rejecting FDR's court packing plan, as the judge referenced, the Democrat-controlled Senate Judiciary Committee wrote this in their committee report. The bill is an invasion of judicial power such as never been before attempted in this country. It is essential to the continuance of our constitutional democracy that the judiciary be completely independent of both the executive and legislative branches of the government. And here's the best part. It is a measure which should be so emphatically rejected that its parallel will never again be presented to the free representatives of the free people of America. This applies doubly to Biden's plan. It's ironic. Here's another quote from President Biden, or then Senator Biden, that Joe Biden once described FDR's plan as a bonehead idea. It was a terrible, terrible mistake to make, and it put into question, if for an entire decade, the independence of the most significant body in this country, the Supreme Court of the United States. But here we are. Biden also proposes to establish a binding ethics code, but he is short on the details. Others have proposed a panel of lower court judges to hear complaints on ethics and recusal violations, have the power to subpoena justices, and then make public recommendations to the court or rule on those complaints themselves. This is also unconstitutional. The Supreme Court is established in the Constitution as a separate branch, and no lower court judge created by Congress can review or sit in judgment of its justices or its work. That would be like state senators or perhaps members of the House of Representatives reviewing and deciding ethics complaints against U.S. senators. If Congress can authorize such a review, why can't it authorize lower court judges to review Supreme Court decisions? That's absurd, but there's no distinction. Some proposals provide for parties to file a recusal motion against a justice, and for 8 other justices, other justices, to determine whether that justice must recuse. This is also unconstitutional and a bad idea. In fact, all 9 justices signed an ethics code in November of 2023 that said individual justices, rather than the court, decide recusal issues. Recusal is a supremely judicial act, and only the justice can make that decision. Even Justice Kagan rejected that idea. And she's been an advocate of some of this reform. Not sure how she gets there, but given these constitutional practical obstacles, it's also important to note that this plan is searching for an imaginary monster to slay. There is no ethics problem at the Supreme Court. Instead, the Democrats and media have invented an ethics crisis because the left disagrees with the Supreme Court's decisions. Before 2020, neither Democrats nor Republicans thought there was an ethics crisis or called for an enforceable ethics code. This despite Justice Ginsburg engaging in perhaps the most unethical judicial act in modern times by attacking candidate Trump in 2016, including attacking him for refusing to release his taxes. The New York Times is giddy that she did this. Later, she heard a case about whether Trump was legally obligated to release those taxes, and of course, he didn't recuse, and she ruled against him. If you use the Democrats' ethics standards they're using today against the court, why didn't they object when RBG, who worked for the ACLU and for many years helped raise money for the pro-abortion group Now, never recused on one case where the ACLU or Now or NARAL filed briefs? She ruled in their favor, I think, almost every single time. Why didn't they object when her husband's law firm appeared before the court several times representing parties, and she never once recused and ruled in the party's favor several times? Why didn't they raise concerns when Justice Breyer went on more than 233 trips paid for by third parties, 63 of them overseas and 17 paid by the Pritzker family, a big Democrat family? The ethics attacks since 2022 are designed to smear the conservative justices. The Democrats baselessly demand that Justice Thomas and Alito recuse from January 6 cases because of their wife's activities. These attacks were designed to try to shrink the conservative majority by forcing recusals on these cases, and short of that, undermine any adverse court ruling. Articles of impeachment were actually filed against both justices for not recusing. Justice Thomas has been pilloried for not disclosing trips with his friends, including not disclosing staying at a friend's summer home, despite a 2012 ruling from the Judicial Conference that said he did not need to disclose those trips. Impeachment articles were also filed for him on this. Democrats have weaponized ethics as an excuse to intimidate the Supreme Court. Now, contrast the Supreme Court to Congress. Congress is the only branch in our government that is not subject to a conflict of interest law. They've conveniently left themselves with no law governing their conduct. Senators vote on matters that directly affect their own financial interests and their spouses' clients. And Senator Whitehouse, the chief critic of the Supreme Court, as Brady pointed out, has repeatedly done this. In fact, Judicial Watch has filed an ethics complaint with the Senate Ethics Committee against Whitehouse in March of 2024 for using his office to help his spouse's clients. But don't expect the Ethics Committee to discipline Whitehouse or do anything. The Senate Ethics Committee has not formally disciplined a senator or staffer in 17 years, despite 1,668 complaints. They took no action against former Senator Menendez, who was recently convicted of bribery and being a foreign agent. So why are the Democrat senators attacking the court when they should fix their own institution on ethics and recusals? An outside ethics panel for the court will further weaponize ethics and recusal matters. The court is different than lower courts in that if a justice recuses, there is no one to take his or her place. And that changes the court's composition, and parties and outside groups will seek to game this fact. Justices already recuse when necessary and appropriate. The justices already abide by a code of ethics. They adopted one. They followed one for many years. They had formally adopted one last November. They are ethical and honorable people, and no one has made any credible argument that there is any corruption in the manner they do their jobs. I will leave you with this one disturbing data point. Venezuela's strongman Hugo Chavez, who was elected in 1999 and was furious that his country's high court kept striking down his laws that were confiscating private property and implementing other socialist policies, packed the Venezuela Supreme Court in 2004, adding 12 justices to the existing 20 justices. According to a study from a Venezuela lawyer, a law professor, for the next 10 years, from 2004 to 2014, the Venezuela High Court never again ruled against the Chavez government in 45,474 cases. This is where we are headed if the Democrats are successful in their efforts to pack the court. Thank you.
Now hear from Professor Frederickson.
Hi there. It's so nice to be with you, at least momentarily and from a distance. I first have to apologize to Brady. He had such a hard time trying to figure out my participation, and unfortunately, or fortunately, in many ways, I'm in the middle of an overseas move, and things just got too complicated for me to be on hand for you. And unfortunately, I can only participate for a few minutes, but I know you'll carry on and have a great discussion. I wanted to just mention a couple of things. One is that I did serve on President Biden's Supreme Court Commission. We considered many of the reforms that he subsequently has recommended, as well as numerous others. And I had the real pleasure of being with you last year in person, where I came to have what I thought was going to be a debate with Ilya Somin from George Mason. I'm sure many of you know him, a really brilliant scholar. And I came into that Federalist Society event and found, much to my pleasure and surprise, that he and I actually agreed on most of the elements of an ethics code. So I would say that although Mr. Paletta and I disagree, and in fact, we testified in front of Congress on opposite sides on this very issue just a couple of years ago, there are many scholars, including conservative scholars, as well as many others, who believe that not only should there be an ethics code, but there can be one enacted by Congress, which is Professor Somin's position, as is mine. As you all may know, currently the justices are the only members of the Article III federal judiciary who are not subject to a written code of conduct. They claim to adhere voluntarily to a code, but it has no enforcement mechanism, and we haven't seen any results from that. And one of the reasons why there has been such an outcry recently is we just know a lot more. And I agree wholeheartedly with Mr. Paletta that previous conduct should have been sanctioned. I don't think that what the justices have done in the past, just because they haven't been, there hasn't been a code imposed on them, that means we shouldn't do it now. I'm fully embrace the idea that all the justices should be subject to it when, for example, Justice Sotomayor has gotten very large publishing advances, and many of the others have gone on luxurious trips with a variety of interested parties. I won't name those justices, but others, as you said, there are groups that have advocated in front of the court where there has not been a recusal. I think all of that needs to be redone. I think this, it's not a partisan issue. The American public agrees with me on that. There's been an incredible decline in the Supreme Court status because of the fact that people are no longer believe that it's the one branch of government that they can trust in. I would say that, as you mentioned, Congress does actually have much more stringent, or it actually has gift rules and disclosure rules that are not only exist, which is unlike the Supreme Court, but are much more stringent than anybody's talking about with respect to the Supreme Court. So, on that issue, I think it's clear that every member of our government should be subject to ethics rules that we are able to enforce as the American public through a mechanism that is independent and has some kind of consequences. And right now, I think it's just highly dissatisfactory that we continue to learn through investigative journalism the lengths to which justices will go to live on the dime of billionaires. It's shocking to me, and I think it should be shocking to all of you. It shouldn't be partisan. It should, in fact, be something we all agree on. As to one of the other issues that I wanted to speak about that I think is quite important, President Biden has also suggested that there should be 18-year terms for justices. I am not to your surprise, fully embrace this idea that, I don't know if this is appealing to many of you, or you believe that we should ever look to other countries. I find it sad that many on the right think that there's somehow something wrong about understanding our own country through the examining what other countries might do. We do that with the states. In order to improve our policies, we should also do that with other countries. We're really unique among modern democratic countries to have our highest court not be subject to either an age mandatory retirement of some kind or a term limit. Most constitutional courts in this category have much shorter terms than 18. They tend to be 8 or 10 years. And let's just analyze. Even if you don't agree it can be done through statute, which I do, there is, again, a very broad agreement here. Clearly, the American public believes very strongly there should be term limits, but also among scholars across the political spectrum. Your own founding member, Steve Calabresi, wrote a very well-known law review article many years ago, arguing that there should be term limits for justices. And in part, he looked at the historical service of justices, which over history had been about 18 years. And many conservative scholars have followed his lead in arguing that there are many distortions in the law that result from people being able to stay on the court until they either leave at a very advanced age, voluntarily or involuntarily. And that is not consistent with the idea that we have an independent judiciary that is respectful of the separation of powers. In fact, it creates a Supreme Court that has more power than any other branch of government, and makes them not just independent, but a force of extreme authority in our system that has really, again, distorted, I think, the law and people's perception of the court. We could go on about, the issues and get into whether it's, how do you do it by statute, or whether you do it by, or it has to be through constitutional amendment, but I don't think I have the time to get into that right now. I hope you do discuss it. I would also recommend that you look at both the report of the Presidential Commission on the Supreme Court that I served on, as well as the American Academy of Arts and Sciences Working Group on term limits, which included conservative scholars as well as more liberal scholars, and advocated a statutory approach that included 18-year term limits. So with that, again, I thank you for being tolerant of me coming by Zoom and not staying for your what I think will be a very exciting debate. And thanks again to Brady for being persistent and flexible with my schedule.
Thank you, Professor Frederickson. We appreciate it and wish you the best of luck in your new position. Mr. Valletta, you have a 2-minute rebuttal, and then we'll get to questions.
Yeah, sure. So we did testify in Congress together. One thing, she's with the Brennan Center, right? Right? Okay. William Brennan, I think, served, who is named after William Brennan Center. 33 years, 277 days. He's the 7th longest serving justice. The founders thought about term limits. They debated them, and I think they wanted justices and judges to not be worried about what comes next, to be fully independent and secure in their job, to do sort of their job unencumbered by what comes down the road. I think that's a good idea. I think judges and justices get better with time. Justice Thomas, I thought it was great, but I think he's really hit, a great stride, and I think all justices do. When you look at some of our greatest justices, John Marshall served for 34 years, Hugo Black for 34 years, John Marshall Harlan with the Plessy dissent, 33 years. Rehnquist, Joseph Story, 33 years. I mean, these are, Clarence Thomas is number 10 now, but you have some of our greatest justices who served a long time. Now, I understand term limits. I'm also against term limits in Congress too, and in in the committee system and that sort of thing. But I respect people who support them. But for the court, I absolutely disagree that you can shorten the term of service by anything other than a constitutional amendment. Biden isn't clear, like I said, Biden's playing games, or this proposal. The proposal, if you want to sort of track what it really does, I think, is to look at Senator Whitehouse's bill. Because, I spent a lot of time on this stuff. When you look at his language in the term active service, and Kamala Harris has essentially told the White House she supports this thing. It's just a, to me, an unserious proposal, right, to appeal to their base, but not do the hard work, which is to say, we're going to say term limits, we're going to dress it up as term limits. And basically, if you are appointing a justice every 2 years, and only the 9 most recent have jurisdiction, that's appellate jurisdiction, that becomes 18 years, right, if you do the math. What's particularly in bad faith here, right, is that they're talking about this now, right, when the first 3 people who go out are Thomas, Alito, and Roberts. I mean, this is why we're talking about term limits. When have they been talking about term limits until a hot minute of the court coming down with these decisions? So looking at other countries, I'm okay with that. I think ours is the greatest country, and we have the greatest founding. If we're going to look at that, I think Europe, in terms of abortion laws, I like to hear when the left talks about looking to Europe, because Europe has, I think, mostly every single country except the United States, has a cutoff of 15 weeks or 8 to 15 weeks for abortion in all of Europe. We're the only country in the world. So if they want to talk about looking at other countries, I'm happy to do that. I think term limits are not good for justices. I'll leave it there. There's some other things, I guess, but we can have an exchange here.
We'll pick up on some of these things. I want to pick up right where Professor Frederickson went off, which is go look at the Presidential Commission report, right? So I did that for you, believe it or not. I read all 250 pages, so you didn't have to. And I want to pick up on the term limit point, because here's what the report actually says regarding term limits. Quote, throughout most of American history, members of Congress have assumed that the only constitutional way to achieve term limits for Supreme Court justices is through constitutional amendment. Starting as early as 1807 and continuing to the present, more than 200 proposals have been introduced in Congress to amend the Constitution to establish term limits for Supreme Court justices or for federal judges more generally, sometimes in conjunction with other changes, sometimes as standalone measures. The first bill to establish the functional equivalent of term limits by statute was not introduced until 2020. The very idea of mandating limits by statute is a recent innovation. By the way, it's from page 136 of the report, if anyone wants to check. Let me go somewhere else. Go to Alexander Hamilton in the Federalist Papers, since we're in a Federal Society. Here's what Alexander Hamilton said, quote, nothing can contribute to the judiciary's firmness and independence as permanency in office. This quality may therefore be justly regarded as an indispensable ingredient in its constitution, and in a great measure as the citadel of the public justice and the public security. So I guess my question is, hearing the presidential report, looking at what Hamilton said at the time about Article 3, who's right? Who's right about whether it needs to be an amendment or a statute? And why or why not? Why is one side right about that and why is one side not right about that?
Yeah, again, I think the Constitution says for good behavior, I think, and so that's been always regarded as life tenure. They talked about that in, Hamilton in the founding debates. And I didn't know that about the first time. This was 2020. So it's pretty self-evident. And this is why, again, I really do think the Democrats, I don't want to get partisan, but I do think the Democrats are just absolutely crazy or gone into overdrive on trying to thwart this court. And it's the first conservative court since 1930. It's amazing, right? That the last time the court was kind of like that was in 30. And what happens? FDR comes and tries to crush it, right, with this outrageous proposal that everyone has a blowback on, including the Democrats. So it is a constitutional amendment. They need to do the hard work and convince the American people to do that. Do I think it's going to happen? Absolutely no. It will take 20 years or whatever that, but it will go nowhere. So this is why pushing, and again, sort of, it's Sheldon Whitehouse, I think, who came up with this idea of like, this active service idea. And again, the convenience of who are the three longest serving justices, the conservatives that have been a burr in their saddles. So I think they're bad ideas. I think it needs a constitutional amendment. Yeah.
Okay, so there's really two, the question before us is does this deserve support? That's the question. And so it really calls to mind two things that we have to talk about. One is the legality. Is this legal? Or what do we have to do to make it legal? And that was the last question. But the other is the normative question. Should we do this or shouldn't we do this? So let me ask the normative question on term limits.
Yeah.
So two of the commissioners appointed by President Biden to serve on his commission on the Supreme Court were former federal judges Thomas Griffith and David Levy. David Levy, by the way, is the former dean of Duke for about 10 years. Now they wrote a separate statement it's literally stapled to the back of the final report. In their separate statement, Judge Griffith and Dean Levy wrote this: in our view, most of the proposed reforms discussed in the commission's report, including term limits, are without substantial merit. They are not related to any defect or deficiency in the court or its procedures, and they threaten judicial independence. We must not permit the Supreme Court to become collateral damage in the divisiveness that marks the current age. Nor should we fundamentally alter the court because of disappointment in particular decisions of the court. There is far more at stake than the outcome of any one case. Another commissioner, Professor Adam White, he's a professor at George Mason, also wrote about term limits in his separate statement that's attached to the report. And here's what he said, quote, upon closer inspection, judicial term limits are much more problematic, especially when they are intended to allocate appointments on the calendar of presidential terms. By tying Supreme Court vacancies and appointments directly and exclusively to the outcomes of presidential elections, a term limits framework would further corrode the appearance of judicial neutrality and independence, making the court a spoil not just of politics, but of presidential politics exclusively. And I guess my question is, hearing those statements from three people who served on the commission with Professor Frederickson, do Judge Griffith, Dean Levy, and Professor White have a point in their critique? And if so, why? Well, what is the normative problem? Put aside the constitutional one, the normative problem with term limits.
So I think Adam makes a great point, and I did read his statement at the time, which is you introduced this idea that, in your second year or your first year, you were going to have a Supreme Court appointment, and people will be kind of, you never know when is going to happen, and do lower court judges audition for them in a way? Sure. But when you have a specific time and it's within a certain, a part of a presidential term that the president can say, I'm going to run on this and I'm going to do this, I just think it makes it much more connected to the political process. And then on the back end, like I said, there are some conservatives like, a lot of people like term limits, but to me, when you think about having judges keeping up with the times, you're thinking about judges who are going to reflect the current day thinking, right? Almost like a legislator, the living constitution. So I do think that, liberals, people who view a living constitution as a good thing, judges should evolve with how phrases in the court and the constitution should be applied. They like that, so they want somebody who's more contemporary. So they want term limits to kind of get newer thinking in their mind. If you're an originalist and you're applying the Constitution and trying to figure out the meaning of those terms at our founding and applying it, it doesn't matter how long you're serving. You're going to have the same answer. Now, you may do more work and discover more things, but the bottom line is you're looking back. You're not trying to keep up with the times. And if the American people don't like it, they can do an amendment, they could pass a law, whatever it is, the choice is going more to the democratic process where it should be. And I think originalism, separation of powers, why that's a better way of doing it. So I do think that, now, I don't know if Steve Calabrese has changed his mind, as he has on some other things, but I know he's written that piece. I don't recall reading it, but in any event, I'm against them. I think, as I said, some of our greatest justices have served long time, and it doesn't detract from their jurisprudence. I think Professor Frederickson talked about some of them get old. for sure. I think William O. Douglas was not entirely there at the end, but that's a different issue, I think. You'll have that anyways. You could have a term limit of somebody who gets dementia in their 10th year, you know what I mean, out of a 15-year term or something like that. So, and refuse to resign. So I think term limits are bad.
So I want to do the same thing with the third prong of President Biden's proposal, which is the code of conduct. So I want to ask a constitutional question and then the normative.
Yeah.
Okay. So on the constitutional one, as Professor Frederickson told us that it was her view that this could be done by Congress. Let me present what I think is a different view and ask you what your thoughts are. So in 2022, Professor Stephen Gillers, who has taught legal and judicial ethics at NYU School of Law since 1978, testified before a subcommittee of the House of Representatives. I know you're familiar with it because you were a witness at the same time. And here's what he testified. He said, quote, that I doubt that Congress can prescribe ethics rules for the Supreme Court, which, unlike other federal courts, is created by Article 3 itself. In other words, because other courts are inferior courts that are created by Congress, Congress can put conditions on those courts, but can't because the Supreme Court is created by the Constitution itself. Do you agree with Professor Gillers that any Supreme Court reform plan that includes a binding code of ethics would have to come not just from Congress, but an amendment to the Constitution, and why so?
Yes, I mean, the Supreme Court is established in the Constitution. You know, there's nothing above it. Nothing can review it. Nothing can, review its decisions, or in my view, its conduct. Now, you have criminal laws that apply. You know, if somebody's bribery or something like that, right? But in terms of their judicial duties and reviewing them, and I do think it would need to be a constitutional amendment. And when you look at what is going on in terms of these ethics proposals, you know, this is the bill right here. Senator White has the bill. It's just this full-on assault to try and, you know, go after the court with all of these probing things to kind of to play gotcha, or to subject it to Congress actually and bend its will. And so I do think I think it's a bad idea. You know, like, to me, it's like, there's nothing we can talk about. There's nothing wrong with the court. The court is doing well. You know, it's been attacked. But to answer your question, we thought about that. You know, but yes, I think you need a constitutional amendment to do anything. I think Gillers is a very, very prominent and, you know, long time, maybe 40 years, judicial ethics expert. And he testified that which was you know, I guess he's always been there, but that you can't do that to the Supreme Court short of a constitutional amendment.
Okay, so then I want to ask you the normative question, and I want to focus on one particular part of the proposal. So if you remember my quote from the Washington Post article, it had not just conflicts of interest that the justices have, but that the justices' spouses have. So I want to ask you about that.
Yeah.
So President Biden's Supreme Court reform proposal calls for mandatory recusal from cases in which justices' spouses have a conflict of interest.
Yeah.
In 2011, a then prominent circuit judge wrote this about spousal-based recusal requests. It's a long quote, but bear with me. I think it's worth it. And then I want to ask Mr. Palette's views about it. Here's what this prominent circuit judge wrote. Quote, my wife's views, public or private, as to any issue that may come before this court, constitutional or otherwise, are of no consequence. She is a strong, independent woman who has long fought for the principle, among others, that women should be evaluated on their own merits and not judged in any way by the deeds or position in life of their husbands, and vice versa. I share that view, and in my opinion, it reflects the status of the law generally, as well as the law of recusal, regardless of whether the spouse or the judge is the male or the female. My position is the same in the specific case of the spouse whose views are expressed in the capacity as an officer, director, manager of a public interest or advocacy organization that takes positions or supports legislation or litigation or any other actions of state, local, or national importance. So the quote's longer, but that's enough. I guess my question to you, Mr. Paletta, is, was Judge Reinhart right in 2011 when he wrote those words? Should we require mandatory recusal because of the public and private views and actions of a judge's spouse?
So there's the opinion that he wrote, and I'll tell you what the case was about. Is long. I cite it all the time. I've probably written 20 op-ed citing this opinion. Here's the case, and it's really important. This is where people talk about, oh, is this whataboutism? You know, I came into this with these attacks on and my friend Justice Thomas and wanted to learn. You know, I wasn't a judicial ethics expert, spent a lot of time reading and looking and reviewing all that kind of stuff. And I came across this case. And so it's important for people to understand because I do think there's this kind of gaslighting that goes on. So what is that case? That's, I think it was 2011. There was a California amendment to their constitution to ban same-sex marriages in California. Okay, to amend the California state constitution to ban same-sex marriages. It passed in California. It was there. You know, a number of people sued to say it was unconstitutional, and it went to the district court. And in that district court, a woman by the name of Ramona Ripston, who was the executive director of the ACLU Southern California chapter, was very outspoken of how unconstitutional, how outrageous this law was, or this amendment. And they joined 2 amicus briefs in the court, in the district court. It goes up to the Ninth Circuit, and who's sitting on the panel that gets assigned to this case? Stephen Reinhardt, her husband. Okay, so here you have the ACLU's executive director having joined 2 briefs on the exact legal issue, the case that this was unconstitutional. It comes up to Reinhardt, and he writes this opinion, refusing to recuse. Okay, and it's chock full of great language. Okay, about how my wife has her views, I have my views, and he says by the virtue of our marriage, we have the same values and think a lot about the same things, right? In the same way. But she's not me, I'm not her, and she can go out and advocate. Here's the kicker. So you can say, oh, this judge is wrong. Stephen Gillers, and I think 5 or 6 other legal experts, this case went up to the Supreme Court, and they filed an amicus brief that was even more on the side of this is outrageous that anyone would think that a judge has to recuse because his wife has taken a public position in the very case that was before him. And so now it's an amicus case, okay? So when you talk about recusals, I do think, and the court does, but if you look at the court's code of ethics, which they followed it formally, they have formally adopted a code in November 2020. It has the exact same language of what's called 28 U.S.C. 455, which is the recusal provision, okay? And so if your wife is a party to a case, if your wife or spouse, your husband, is a lawyer arguing before the court, if you have a if you're going to be a witness in that case, something like that, yes, the judge should recuse, and justices do recuse on those sorts of things. The Supreme Court, because they call it the rule of necessity, the Supreme Court, as I mentioned, is different than other courts. So if a justice recuses, like if Judge Luck has to recuse, somebody on the 11th Circuit would take his place. So you'd have a 3-panel judge, okay? You wouldn't have somebody as brilliant as Judge Luck. You'd have a judge there. You have three people on the panel, okay? As the Supreme Court, when there's a recusal, you go down to 8, okay? You are down a judge or a justice, okay? And so the court says, we're going to follow this, but because it changes the dynamics so much, okay, we're going to be much more limited in this regard. This came about actually because it was Chief Justice Rehnquist's son was a lawyer at Boston firm, but he was working on a Microsoft case, and it went up to the Supreme Court. He wasn't before the court, but he worked on it at the lower level, and he issued an opinion. The court actually issued an opinion in '93, an ethics opinion, saying, "Look, if a family member was involved below, not the lead lawyer, but below, but not before us as a court, we are not going to recuse." Okay, kind of this rule of necessity. So I came into this, looking at these issues and what I call the gaslighting. I'll also say my wife and I, we met here at Georgetown Law School. She's a practicing lawyer. She's been in a law firm for many, many years. So this idea, we have our own practices, we're married, somehow, whatever she thinks what I think, right, is just offensive to me personally. And so I do think the American people get that, and they don't think, that you have to recuse. We'll take it to Justice Thomas, like again, so just in terms of what I call it the gaslighting, but 2012, Ginny Thomas, okay, in full disclosure, I represented her in the January 6th investigation in Congress. Ginny Thomas said that the Obamacare should be repealed by Congress. Not that it was unconstitutional, but that it was a bad law, a bad policy that should be repealed by Congress. There was a move to impeach Justice Thomas because he did not recuse from the Obamacare cases because his wife was over here in this lane, okay, talking about the political dynamics of it, right? She didn't have, she wasn't before the court, she wasn't a party, she wasn't, she didn't file a brief, okay? But everyone lost their mind, and the New Republic said that Justice Thomas should be impeached. I think that's ridiculous, okay? I have more faith in our justices that they are good and honorable people. Now, I will tell you, if you notice the language I use in terms of some of these issues I raised before, what I said was if the left uses the standards that they're using now, why weren't they upset with Justice Ginsburg? Okay, now going back to that, Justice Ginsburg's husband was a lawyer, passed away, at a big law firm here in town. He wasn't a partner, and so he wasn't involved with those cases that came before the Supreme Court. Okay, they weren't his clients, but they were his firm's clients. Okay, he didn't share in the profits. So under the court's rules, she didn't have to recuse, okay? Do I think Justice Ginsburg would change her vote because of her husband's law firm is there and I'm a client? No, I don't, actually, okay? But if you're gonna play this game that they do with Ginny Thomas or even more crazy Martha Annalito flying a flag, and somehow that's going to force you to recuse, this is just inventing recusal standards to go after these conservative justices to either force them to recuse, so you shrink the conservative majority, or short of that, because they wouldn't recuse, just dirtying up the court, so you can talking about court packing and outside code of ethics.
I think we have time for one more question. I'd love to take one from the audience if you have. I saw your hand first, so I'm going to go with you.
So under Johnson, Abe Fortas resigned because of financial impropriety, where he acted as a consultant for a firm. He got paid.
Yeah.
He returned the money, but that was considered too much of a scandal for Congress at the time, and he was put under pressure. To what extent do you think that serves as a counterexample for many of the modern examples for the lack of recusal? If that is a standard for when a justice not only recuses but resigns from the court, should we have a more stringent ethics version?
Well, again, just in terms of, as I understand it, if I recall the Fortas one, he was his wife was involved. I think it was clearly he was doing work or representing or helping a client. Nobody's done that, right? I mean, again, in terms of you can raise an example for me, but there's none of that, right? The questions are: I have a friend, particularly, I have a friend who's a wealthy friend, and I go visit him, and I go on trips, and the judicial conference ruled out in 2012. So nobody's been accused, like Senator Menendez, of being a foreign agent, right, selling our country out. Okay, and the Senate Ethics Committee not doing anything on that. That is a crime. Okay, there's nothing like that, and that's the thing with all of these justices. Even justice, like, again, my view is you need to kind of. If people are going to raise ethics issues on my friends, I'm going to raise ethics, on other people. Okay, so but Justice Sotomayor, she forgot to disclose 6 trips for 6 years. Okay, that were paid for by. That's a mistake. Okay, but nobody, to my knowledge, nobody has taken any money or done anything in return for like a service as a lawyer or as an inside source on the court. And so I think that's just apples and oranges. And I'll just say, quite frankly, back in the day, when you look at what justices did a long time ago, even our greatest justices, okay, they were doing that, okay, and they were advising presidents, and they were doing lots of things that people today would, but were they great courts, and did they, do great opinions and all that? Yes. So this idea of like this gotcha idea of trying to, I call it dirty up the justices with things like, you went to a friend's house and you didn't report it. I mean, literally, you just said. And I've done a lot of writing on this stuff. MarkPala.com is my website. I got about 50 op-eds up there. But, one of them is Clarence Thomas goes to his friend's house in the Adirondacks, and somehow he has to report that, okay, on his form. And you know what? The judicial conference changed that, why? Because they said if it was owned by an LLC, a lot of people, wealthy people have their homes in LLCs or even moderately, that's no longer personal hospitality. It's like, even if it's just a holding company, okay, for estate purposes or tax purposes. So that would mean if you went to go visit your father and his house was in an LLC, you would have to report that. Okay, because it's no longer your father, it's an LLC. So the judicial conference changed that this year. But anyway.
All right, we're gonna end the question period and give Mr. Coletta an opportunity for closing briefly, and then we'll conclude.
Okay, I think the attacks on the court, for both, wanting to pack it and add justices or, add an ethics code, an enforceable ethics code, are not in good faith, and are designed to, undermine this conservative court, first court since, that's been conservative since 1930. Court packing is anathema to an independent court. And it's I won't say shameful, but it's sorry that the Democrats are pursuing, particularly Biden, who said it was a terrible idea over the years. For many years, you guys, conservatives were upset with the court's opinions, right? We didn't go to their homes and, scare their children, their justices' children. We didn't stand on the steps of the Supreme Court and say, I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these awful decisions. He said that when the court was hearing an abortion case on the steps of the Supreme Court. So he's threatening him that if you voted a certain way on a court case, you won't know what hit you. And we know from that an assassin came, a would-be assassin, to Justice Kavanaugh's home to kill him and his family. Okay? I know the justices, I know many of them. They are under 24/7 security with people at their homes, okay? 24/7, okay? The Democrats have fundamentally changed their lives, okay, and their families' lives. And I think that that's wrong, okay? So at the end of the day, term limits, bad. If you want them, you need a constitutional amendment. An outside enforceable code of ethics is unnecessary and is done in bad faith to try and harm the court, do get gotcha sort of efforts with the justices. It's working fine. They should go win elections and appoint justices if they don't like the opinions of the Supreme Court.
Thank you very much.
Okay, thank you so much.